I want to express the fact that I recognize and that I am very sorry about the death of this tragic accident. But the focus here today is on the state's case, okay? Because this is Jason Tarr's trial, and the state has a burden of proof. They have to prove that he did each and every act that they're alleging, beyond a reasonable doubt. There are a series of witnesses that you've heard about that cast some very serious doubt upon whether or not Jason Tarr was intoxicated when he left that golf club. There is very little information at the scene of the accident regarding intoxication. It is minimal. I mean, there is nothing. People are not smelling alcohol. They don't see him staggering, stumbling, slurring his speech. So what we have is a focus on the laboratory, a laboratory result. And the state is wanting you to focus on a number. And I talked to you about that at Board Diary, that this number has great significance, and I know it has significance to you. But when Asclad Labs comes to the laboratory, and when they criticize the lab for its record keeping, its forms, and require the laboratory to do a corrective action report because of their record keeping, am I here in this trial to ignore things like this? When I see the order of things being marked out and notes in the margin being made, and when I see things like a computer run that has computer results of that run, and I note that not on the day of the test, but days later, that important information is being added to this computer data, which is not generated by the computer. Well, I don't think I can ignore that as a lawyer. I don't think that's something I can say is not important. So yes, I talk to experts about that. I hire experts in trials all the time. And the reason for that is that experts who do this kind of work can give us answers that we might otherwise not be able to understand. And I know that during the course of this trial, Mr. Mao heard some things from the messenger, Dr. Pittman, that he did not like. But the argument is not to attack the messenger and somehow tarnish the messenger because he's not saying something that you don't like, because he's saying something that you don't like. Well, Anna Mudd said some things that were very bizarre to us that we did not like. And one of the things is that when we came into this pre-trial, and when we came into this during the first part of this trial, we were playing by what we thought were the rules. It was the rules that the Department of Public Safety had published in their standard operating procedures that says that they measure alcohol in their vials using chromatography with a safety point calibration curve. Yet we find out during the course of the trial that no, we're changing the rules. We're now going to be able to use a response factor. And not only that, when we do these calculations, we're going to put in numbers We don't even know where they came from. I don't quite remember, but yeah, that number's over there. Well, I can't accept that. I don't think you should accept that. And so it's my duty as a lawyer to point these things out to you, because you don't change horses in the middle of the stream, okay? You play by the same rules throughout the course of your evaluation. You don't use one rule when you write your rules and then change them in the middle of the courtroom. Now, Dr. Pittman, what he did was he calculated the alcohol concentration from Jason Tarr's specimen using numbers that he would use if they were using a single point calibration curve. And those peak areas gave him a value that was different from the value that was on that chromatogram. And his value was a 0.082 rather than a 0.103. And he used her own, that is, Anima's own uncertainty value, and recognized that this test number could be as low as 0.07. All right? It could be as high as 0.12 something. But does that give us proof beyond a reasonable doubt of anything? And the point I'm trying to make is, and you've heard my objection, that if the number that we're trying to work with is out of focus here, and at the scene of the accident we have sobriety as the majority of the evidence, then how can we connect these 2 points? Well, we can't. There's no way to do that. Mr. Ortiz, the state's expert, he deals with the breath testing program, and he said everybody's response to alcohol is different. He couldn't give any kind of estimate backwards or forwards about what Jason Tarr could be at any point in time. And Dr. Pittman agreed with him. You cannot calculate things like that when you don't have enough data. And the primary data you would have to have is this cloud, this vague notion of what the laboratory was trying to find. This number that changes during the course of the trial because they change the method by which they're measuring. And the experts agreed there was no way to connect these. As a matter of fact, the certain alcoholic beverages that are carbonated, such as champagne or beer, can cause your alcohol concentration to continue to rise for a long time after you cease drinking. That was their expert who testified to that. So, if it's that vague, then it's really hard to say, well, we can rely on our common sense to do something experts can't do. That is not logical. Okay? So your task is to look at what evidence that you do have. The evidence that you do have are the observations of police officers, firemen, people who are playing golf with this young man, and who were there to see how he behaved, what he sounded like, and whether or not there was an odor of alcohol on his breath. Those are the factors. And in terms of Mr. Tarr not wanting needles put in his arm, I don't think anybody wants needles put in their arm. In terms of the time that it took to get the warrant, I don't know why they took so long to get the warrant, but that's not Jason Tarr's fault, you know. He's there at the hospital sitting there. And the fact is that when we finally get this blood and we go into this laboratory, we get interlineated computer reports, numbers that have changed, and we also see that what they were trying to tell us, that we have a single point calibration curve, which was theoretical to begin with, that apparently we don't even use that anymore. And so we've changed the rules. You can look through this and you remember the testimony, but the fact of the matter is that the testing process was not accurate. It didn't give us the sense of completeness and wholeness that you would want from a good laboratory. Now, they have this accreditation certificate, and it says that their accrediting agency wants to declare to all advocates of truth, justice, and the law that the management and technical operations of the department's laboratory have been found through the assessment to meet the requirements of ISO IEC 17025. Well, I submit to you that that is not true. I'm an advocate. This was a promise made to me. All right? Mr. Mao is an advocate. It was also a promise made to him. But I think because you're interested in justice and your role as a fact finder, promise was made to you as well. And I think the manner in which this test was performed, in a rushed manner, with interlineations made on all these computer papers, and changing the horse in the middle of the stream in terms of the rules of how we measure alcohol concentration, that caused a broken promise to be made by this laboratory. I don't believe that you can rely on their results. You're going to do whatever you want to do when you get back into that jury room. But look at these pieces of paper. They don't look normal. As a lawyer, when I see computer paper that has handwriting on it, I can't ignore it. I have to find an answer for it. And I can tell you that during the course of this trial, I have found an answer. They use numbers that they don't know why. They change their rules in the middle of the stream.